One of the key questions that people who are accused of domestic violence might have as time goes on, as their case goes on, as they have more court dates, is how's my case looking? Is it getting any better? So in this video, I'm going to be explaining 3 factors that will make your domestic violence case potentially better. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be going through 3 factors that can make your domestic violence case better. Things that are making it look like you might win this case, that the prosecutor might give you a better offer, that the prosecutor might dismiss the case altogether. Okay, so let's jump right in. The first thing that can make your domestic violence case better is if the victim has made inconsistent statements. And by the way, victim is the legal name for the person accusing you. So we're not agreeing that they're actually the victim of anything, but that's their name, just like if you are charged in criminal court, the term to describe you is the defendant. So whenever you're charged with domestic violence, it is typically going to be a he said, she said. And I know when people say he said, she said, many times they are implying that the evidence isn't strong, but you can definitely be convicted of domestic violence or even more serious crimes based on the word of one person. When a lawyer is evaluating how strong your case is, one of the key things that they're looking for are inconsistent statements. Because if someone is telling the truth about something, typically they are going to be pretty consistent. If they don't remember something, then they'll say that they don't remember. But what they won't do is change important details in the story. They're just telling the story as they remember it. So when I'm defending somebody who is accused of domestic violence, I want to look at all of the statements that I can find, all the statements in my possession or that I can get into my possession where the victim is describing what happened. So if they called 911, then I want to make sure that I get a copy of that 911 call so that I can look at what did they say to the 911 operator. Okay, then the cops come out. What did they say to the cops? And I'm not just looking at the police report. I want to get body-worn camera if it exists and listen to exactly what they said. Did they describe things the same way that they described it on the 911 call? Now, those 2 events are probably pretty close in proximity, so they might be accurate. Okay, but what about if they filed a restraining order? Maybe that happened a month later, a few days later. Maybe they decided, you know what, I'm going to beef up these accusations and make them even worse to increase the chances that the judge will grant a temporary restraining order in my favor. Okay, well, I want to look at exactly what they wrote. Did they change their story from the 911 call to what they told the police, to what they wrote in their application for a temporary restraining order? Sometimes then they go to court for the restraining order. Did they make statements there? Did those change? Now we have 4 different stories potentially. If it's a felony case, then we get the opportunity to ask the victim questions and get them on record at a preliminary hearing. A preliminary hearing is basically a probable cause hearing, but the alleged victim or any witnesses generally will come in and tell their side of the story. So did the story change there? Now we have potentially 5 different times. What I will typically do, especially if I'm taking the case to trial, is actually make a chart of each detail and how they described it at each time. Now, really minor differences are not necessarily going to be a big thing, but many times I can find major differences, especially if the person is lying. So if there are inconsistent statements by the victim, then that is going to make your domestic violence case better, meaning that you have a better chance of winning, you have a better chance of getting a better deal, you have a better chance of the prosecution deciding that they will willingly drop the case altogether. Number 2, if you as the defense, meaning you and your attorney, if you are able to disprove statements that the victim made, things that she claims, then that is also going to help your case significantly. For example, if she claims that she dumped you and didn't want to have anything to do with you, but there are text messages where she clearly does want to be with you, or text messages where you clearly didn't want to be with her and you expressed that to her, then that is also going to help your case significantly. The third thing that can help your case is if the victim contacts you. Let's say that the victim is adamant that you were abusive. The victim is adamant, and if they show up in court, they're going to say that you abused them. Then if you have text messages after the time that you were arrested from the alleged victim, it doesn't mean that your case is going to be dismissed. But it does mean that it might make your case look a lot better. And now, look, I mean, how courts and how prosecutors view these cases is typically sort of like the victim suffers from battered woman syndrome. And so we can't even trust what she says at all if she wants to testify in favor of the defendant. We can't take what she says at all as being the truth. If she says she wants to drop charges, we don't care about any of that. She obviously doesn't know what the heck she's doing because she is a battered woman. So it's not like the case is going to be dismissed just because the alleged victim now wants to get back together with you or wants to drop charges. But it definitely looks good for you. And I've had cases where the alleged victim, if they come into court, is going to be adamant that they were abused, yet they're hitting up my client saying, "You up? I want to drop these charges." And when my client doesn't respond, they come into court and now they're saying, "Oh, I was the victim of this horrible abuse." They'll even start crying. What they're probably crying about is the fact that my client's not texting them back. And so if I have text messages saying, "You just texted him last night, you texted him last weekend, you keep texting him, you keep hitting him up," then that is going to help the case look better. And at trial, in front of a jury who sees all this, who sees this is somebody who claims that she's a victim of this horrible abuse, but she's hitting up the defendant in a romantic way or sexual way this entire time, do we really want to convict him of this? Can we really say beyond a reasonable doubt, just based on her word, that we should convict him? I hope you found this video helpful. And if you have been arrested for domestic violence, but you haven't been to court yet, the number one thing that people don't know to do, but is really important, is you need to have an attorney contact the DA before court and try to get the case dropped. But if you have been charged with domestic violence, your case is already in court, then these are 3 things to use to evaluate your case. And if you do have a domestic violence case in California that you would like help with, you can feel free to book a consultation. My phone number is in the description box down below. You can also find a link there to book the consultation. And if you did find this video helpful, please don't forget to like, subscribe, and ring the bell.